talk about what's happening in Parliament now, because the seeming standoff between the House and the Supreme Court on the declaration of 4 seats vacant in Parliament has taken another turn as the Speaker, Alban Somana Kingsford Bagbin, has directed the Clerk of Parliament to return court documents served by bailiffs on the parliamentary service. You recall that the Supreme Court on Friday, October 18, issued a stay of execution on Speaker Bagbin's ruling, which declared 4 parliamentary seats for Mena, Agona West, Memphis Central and Suhum vacant. The ex-parte application to stay the Speaker's decision was filed by MPP MPs led by Alexander Afenyo Markin, who saw the court's intervention to halt the enforcement of the ruling that would affect their majority status in the House. Following from that, last Tuesday, October 22, Alban Bagbin, Speaker, adjourned sitting Sinidine when the NPP MPs walked out after the NDC members of Parliament occupied the majority side of the aisle. As NPP MPs gather signature for Speaker Bagbin to recall the House to attend to emergency government business, the Speaker has responded to the Supreme Court service of the court document to Parliament, citing constitutional immunity under Article 117 of the 1992 Constitution. So let me read to you that letter. The Speaker ordered the Clerk of Parliament, Ebenezer Ahoma Jetro, to write to the Registrar Supreme Court, Accra. It says, I'm directed by the Right Honourable Alban Somana Kingsford Bagbin, Speaker of Parliament, to return the attached processes which was left at the Legal Service Office of the Parliamentary Service by 3 bailiffs of the court on Wednesday, 16th October 2024. Attempts were made to serve the same processes on Tuesday, 15th October 2024. The Right Honourable Speaker notes that the attempted service is contrary to Article 117 of the 1992 Constitution and the circular issued by Her Ladyship Justice Sarah Pamela C.A. Coranting J.A., the Judicial Secretary, and copied to the Honourable Lady Chief Justice with reference numbers SCR 9 entitled, quote, Enforcement of Article 117 and 118 of the Constitution, Immunity from Service of Process and Arrests, unquote, dated 12 July 2024, addressed to all registrars of the courts. Consequently, the Right Honourable Speaker has directed return of the attached processes to you for your necessary action. Kindly accept my highest regards. Signed, Emmanuel Ahoma Jetro, Deputy Clerk. And this is also copied to the Right Honourable Speaker. This is to the Registrar of the Supreme Court, Accra. And that's the communication from the Speaker of Parliament. So let's speak to a constitutional lawyer, Mr. Paul Kumi. Good evening to you, sir. Very grateful for your time tonight on 505.
Same here.
Just as we thought that, there could be an amicable resolution to this Supreme Court Parliament fracas. Here we have it. We have returned service. What does this actually mean?
Well, when you check on the issue as raised in the Speaker's letter, he raises some few important constitutional provisions, and that is in respect of service of rights of summons and other court processes on persons who work in Parliament. Talking about the Speaker of Parliament, the members of Parliament, Clerk of Parliament. Now, it is clear that when there are such persons on their way to Parliament or their way from Parliament, or whilst in Parliament taking parliamentary work, no processes can be served on such persons. That is what the Constitution is clear about. Of course, that is in respect of Article 117. If you look at 118, it is in respect of asking such persons like a Speaker or a Member of Parliament or the Clerk of Parliament to go to court and, as it were, probably testify. So you realize that it does not talk about a Member of Parliament going to court or standing trial even when he's on his way to make offense like that. So in this particular instance, the service as was effected at the legal department since against the provisions of Article 117. Now, there has been a certain gentleman agreement, but before I get to that one, so what it means is that if you are going to rigidly interpret the Constitution, it will mean that you can only serve a member of Parliament when he's not on his way to Parliament or
when he's
returning
not
from
doing,
Parliament.
or when he's not doing
Yes,
any
so-
parliamentary duties
Yeah, so possibly the only time you can have him will be in his house,
in his house.
right?
But if you meet him in his
This
house
was
and he
what-
opens his gate and he says, "I'm on my way to Parliament,"
Well, if he does say that he's on his way to Parliament, you cannot force him to serve it on him.
okay,
Possibly, he may do some further inquiries to check to see if indeed what he told you is true, that he was going to Parliament, and that he was going to Parliament in respect of attending to work, which is official in Parliament. So as I was saying, it was as a result of some of this rigid interpretation which was making service a bit impossible. And I remember the case of these MPs, I think Okujeta Blacka also, when he said that, he could not be served the process, and it was thrown at him, I think at the premises of the court or thing.
no, and a TV station actually.
Come again?
It was served on him at the premises of a TV station when he had gone there to
Okay.
do an
Thank you for
interview.
that correction. Yes, so these were creating some difficulties. So I think there was a certain gentleman agreement between the Speaker of Parliament and the Chief Justice that all such processes meant for Parliament, MPs, Clerk of Parliament, Speaker of Parliament, they should do that on a Monday, so that whether the person is going to Parliament or is coming from Parliament or he's sleeping in Parliament, when that process is set on the Monday at the legal department, then the persons involved could be informed and it will be presumed that those persons have been served. Now, when you look at the processes that were filed or supposedly served on the Speaker, there was the attempt on a Tuesday. Mind you, the agreed day is Monday. But the attempt is on a Tuesday. It wasn't successful. Then on the Wednesday, they went to the legal department and they deposited the process over there, and then they left. But of course, there has been an official information given out to all registrars in Ghana in respect of how such processes might be served when it involves Parliament. So then one wonders how the said registrar will have to now allow this filing to be done and the service effected
Okay. Now,
on Parliament
now,
when it is not a mandate as agreed between the two.
now I have a
Because-
question on that because, again, you see when Speaker raised that matter on the floor on the Thursday after he had declared that seat vacant, Afenyo Markin talked about the fact that there was a service, and the Speaker even went ahead to tell us how he was served, and he talked about the fact that they left the legal documents on the table. The Friday when they went to court ex parte and the judgment was done, the Chief Justice said that the Speaker said because it was not a Monday and because they didn't serve it, they considered that as service, and that's how they granted that stay. So I'm wondering how the court that had a gentleman agreement with the Speaker of Parliament that service should be done on Monday will on that same Friday accept that although it was not a Thursday and the Speaker had issued that it was not a Monday, accept that the service was done in their ruling on that Friday.
Let me not be temptation. I believe that the jury is out there. But what I'm saying essentially is that if we are going back, we are going to put aside the gentleman's agreement in respect of the Monday set. Then we are now going to have the written interpretation of the Article 117 provision of the Constitution. He says that you cannot serve the person when he's undertaking parliamentary work, either on his way to or on his way from, or even in Parliament undertaking parliamentary activities. So, if there has been this gentleman agreement that you can serve me only on Monday, and you didn't do that, right? But you decided to bring the thing on a Wednesday, and now you want to, as it were, shift the goalpost to say, oh, because I have said I have notice of it. Then I would say that, yes, I did have notice of it, but I'm saying that fundamentally and constitutionally, they said it is wrong. So I have not heard it. Or I'm not in receipt of it. So I know some people are going to say that, oh, the speaker spoke about it and this, and that constructively he has noticed. Yes, he does, but he's saying that the whole service is a nullity as per the Constitution. So I'm not going to receive it. So even if I was magnanimous or truthful in telling the whole world that I'm aware that there has been a process served me, right? One was expecting that the Supreme Court will have said that, okay, look, there is this agreement between ourselves and Parliament. The process must be served on Parliament on Mondays. This was not done on the third day, right? And so we think that probably the service was not proper. And then some other explanations will have been done. Some very nice, that's a very nicely crafted expression will have been done, right? But if the argument is going to be that, oh, you have heard it, you even spoke about it, and to that extent, we think that there is proper service on you. Then he said, oh, is that what you are saying? Okay, then I'm also going to make reference to the Constitution. You came and left this thing at the legal department. You are supposed to serve it on me. And if you are going to serve it on me, it is not supposed to be in Parliament. I hope you understand what I'm saying.
Yes, I do.
So I think that the way this thing is going, if we are not careful, we're going to have a very serious constitutional crisis on our hands. What it means, therefore, is that the Speaker is not recognizing the orders of the Supreme Court. And so even when under the NPP's memo to the Speaker, even when he recalls Parliament, is Parliament, but recognizing the group which has a bigger number in Parliament after his information that is given out as the majority.
But will the timing of the recall also not be, because the Supreme Court ruling, the stay is supposed to be for like 10 days. And so if Speaker decides to recall Parliament somewhere next week, Tuesday, the 10 days would have elapsed. So the Speaker will still go ahead with his own ruling of the 4 seat being vacant, and the NDC will still occupy the majority.
That can be another thing. But something which is creating a bit of incongruity in respect of the Speaker's stance is that we have information to the effect that the Speaker had asked his lawyers to file a motion to set aside the order as directed by the Supreme Court to stay the execution of the information he gave. So to the extent that is, if that information that I heard is true, that indeed the Speaker's lawyer had reacted by filing the process at the Supreme Court to stay the stay of execution of the Supreme Court, then it is a bit of an incongruity if he now turns out to say that he was not going to receive a service. Because if you have not received any service, then you are reacting to what? I hope you understand what I'm saying.
Yes, I do.
Can you hear me?
Yes, I can hear you. Can you hear me?
Yes, I can.
Okay, great. So then it means
Yes,
we are in for some legal battle, a long one.
Seriously. So in sum, what this means is that the Speaker under the Constitution is obliged to recall Parliament. So he is going to do the recall. But with what the Speaker has said, and relying on Article 117, and again on the circular of the Chief Justice under the hand of the Judicial Secretary, it means that when they should meet on any day of the recall, he is going to look at the group who, by his ruling or information given on the 17th, to have a bigger number as those who are in the majority.
Okay. Mr. Kumi, very grateful that you joined us. That's a constitutional lawyer, Mr. Paul Kumi. Let me read some of your